So who was fighting for the appropriate role of the states' rights? Well, there were people in Congress fighting for it, but I'm going to talk about how the Supreme Court was trying to fight it. So Justice Rehnquist is appointed to the Supreme Court, and then Justice O'Connor, and they are states' rights people in the appropriate level as an alternative locus of power. And so in a great case, a very interesting case called National League of Cities versus Usry, Justice Rehnquist looked at, he's now Chief Justice, he looked at the expansion of the National Labor Relations Act to cover state employees. And he got a vote of 5 votes to strike it down. He struck it down as applied to state employees. As applied to private employees, under the expanded view of the Commerce Clause, the federal government could do it. But he wanted to create a safe harbor for states to operate. That was the program. How do we keep states having a safe harbor from this behemoth federal government? That was his program. And he said, those things that are really integral to state operations, like police and fire, maybe teachers later on, federal government hands off. Let the states decide how much to pay them, how to allocate resources. This is the state's safe harbor. It's what the state's sovereignty was about. Protection, fire, maybe education. Federal government states. So he had given a safe harbor. And then 8 years later, he lost it. Justice Blackmun jumped ship, and National League of Cities was overruled. And Justice Blackmun said, sorry states, you're only going to have to go through the political process to protect yourselves. And don't worry, he wrote in his opinion, Justice Blackmun, the states have plenty of heft in the political process in Washington. Well, Justice Powell wrote a concurrence and said, are you crazy? The states have heft. Number one, they don't control the Senate anymore. That was back in the 1920s. They lost control of the Senate. We now elect the senators. Number two, the states don't, the congressmen who come from the states hardly ever see a piece of legislation. Have you ever heard of Obamacare? That's typical. That's typical. Who writes the legislation? Career bureaucrats who are the staffers of the permanent committees. They write the legislation. How are the states ever going to get in to see what's to their, what's going on there? So therefore, the states really don't have a political process protection. We're the ones, the court, is going to have to create the safe harbor. You can't rely on the political process. Well, he didn't concur, he dissented on that. And then a couple of years later, there was a case in which the federal government decided to tax bearer bonds issued by the state on state facilities, which previously had been exempt. And South Carolina said, wait a minute, how are we going to fund schools if you're taxing these bearer bonds? This is a very discrete area. Justice Brennan says, so, and South Carolina, taking Justice Powell's dissent in the Blackmun case, said, look, the political process doesn't work. We're getting steamrolled. And Justice Brennan says, political process, we don't look into the political process. He's actually right. The court should not look into the political process. The court should draw boundaries about how far the political process can go. But it shouldn't look over and say, oh, did the congressman really represent the state? That's not the court's business. So the political process is not up to the states. So they lost that battle. Well, what was this? Well, Justice O'Connor thought she could save something. And in a case called New York versus the United States, she found out what she could do. In this case, the federal government was trying to take care of nuclear waste products. And it said to the states who were fighting over, I don't want your waste, no, I don't want your waste, right? New Jersey said, I don't want New York's waste, we've got plenty of it. I said, well, so New York says, that's what you're there for, New Jersey. So they had this very complicated scheme about how they're going to take care of nuclear waste in their landfills. And Justice O'Connor said, you know, you've got 3 options, federal government, that you've given the states. 2 of them are constitutional, but one's not. Well, which ones were constitutional? Well, you can tell the states, if you do it our way, federal government's way, we'll give you a lot of money. States love a lot of They sell their souls all the time, right, to the federal government for a lot of money. But then, so Justice O'Connor says, you still have a choice. You still can say, of course she didn't know it, we don't want that high-speed railway, right? You still can say no. Or the federal government can simply say, step aside, states, we're gonna regulate the thing directly under the commerce power. Okay, nothing you can do about that. But instead what the federal government said in this case is, this is what we want you to do. We'll give you a choice. How's that? Here's your choice. What? You take title to nuclear waste plants, dumps. In other words, anybody who winds up with 3 ears or something will have to sue you. Or you pass a piece of legislation as we tell you. O'Connor says, that's unconstitutional. You're conscripting the state's own sovereign processes of making decisions. You can't do that. You want to do it your way? Tell the states to step aside under the Supremacy Clause, go do it yourself, but do not conscript the states into the federal government's power. So we have this narrow safe harbor now called, you cannot conscript the state legislature. You can buy its soul, but you cannot conscript it. And then that was extended in a case called Prince to state executive officers. Under the Brady handgun law, state, local law enforcement officials were required to do the background checks for gun purchases. And the Supreme Court said, no, you're gonna have to hire your own federal officers to do that, or offer the states money to do that, in which they can say yes or no. But you cannot conscript the state's own executive bureaucracy. Another little bit of safe harbor. Okay, Rehnquist goes, O'Connor goes, what's left? There's not much left. Not much left. But then comes Justice John Roberts. And what I've been seeing over the past 3 or 4 years, or since he got on, is this step-by-step movement to try to create more and more safe harbor. Am I boring a lot of people? More and more safe harbor areas for the state to operate. And the biggest case that came down, from which he got a lot of grief, was Shelby County versus Holder. That was the case in which the Supreme Court declared the significant central part of the Voting Rights Act unconstitutional. Now let me tell you about that case, and then I'll tell you about 1 or 2 more, and then we can be done. Okay, so it'll be about 5 minutes.
We're good.
Okay?
No,
okay.
We're good.
So let me tell you about that case. To understand that case, let me take you back to your childhood. Now, when I was young, not when you were young, not when you were young, but when I was young, we didn't have play dates, right? We didn't have soccer tournaments. We'd go out in the street and goof around. And the girls would always want to play something. What do you want to play? Let's play house. Oh yeah, that's going to be a lot of fun. You be the daddy and I'll be the mommy. All right, fine. I'll play house, but can I go blow up Tommy's house? You know, that. So one of the games, remember the games? There were 2 games we used to play. One was called May I and Red Light. Remember? Taught children opposite moral lessons. Red light, may I was how you should ask permission. May I take 2 baby steps? Yes, you may take 2 baby steps. May I take a giant step, right? Yes, you may take a giant step. So that was, the other was red light, when the person would turn his back to you, right? And you try to sneak up, and he'd turn and say, red light, and if he saw you moving, you were gone. That moral lesson was get away with as much as you can. Without getting caught. So the 2 moral lessons of how to grow up: ask permission, but still try to get away with as much as you can. Well, that's what the Voting Rights Act was. Section 2 of the Voting Rights Act was red light, and it needed. By 1965, the number of blacks in the South who were registered to vote was minuscule. They had been kept off the rolls for a century, and so that was red light. You try to do that anymore, the federal government says no, we can sue you, or private, and private entities can sue you. That has to stop. Literacy tests that were designed to keep blacks off, not poor whites. They would give these literacy tests, which would be really difficult for any person to read, especially a poor person in the South, only to the blacks, and they'd stumble, it was hard. So those were knocked down. So section 2 was the red light section. Section 4 was the may I section. Section 4 required any state designated in the bill, any state that had previously discriminated against blacks for voting, to make no changes whatsoever in their voting regulations, districting, or anything without pre-clearance from the Attorney General. Now think about this. The state government, which is one of its primary obligations, is to organize the democratic franchise. And they have to go to an executive official in another sovereignty to get permission to run its own electoral processes. So they had to get pre-clearance for anything. And that act of 1965 was to expire in 5 years. But in 1970 was passed for another 5 years. And then in 1975 for another 7 years. And then in 1982 for 25 years. And then in 2006 for 25 years again. And that was passed. But by that time, by this time, by 2010, 2011, if you looked at the districts that had to pre-clear to the Attorney General's office, you have to look that blacks were a majority of registered voters in those very same states that previously had been 5%, that they had elected proportionately more office holders than their racial numbers would indicate. In other words, they were doing better than the rest of the country, if better means the number of blacks being registered. Better than the rest of the country. And so one district brought and said, this is now discriminatory against certain states. And the Chief Justice agreed. And this is what he wrote. He said, the states may not be deprived of a fundamental sovereign function, such as organizing elections, without sufficient justifications. Under the 15th Amendment. There was sufficient justification in 1965, but there isn't now. In other words, he's beginning to say sovereign function. Just what Rehnquist did in National League of Cities. A little bit of sovereign function, which is the state. Can be invaded, but Congress has to have a higher level scrutiny to do it. And what Congress cannot do is discriminate among sovereign states. They are equal in dignity. Oh, and when he did that, he went right back to the founding. Because one of the founding documents of our nation, one of the great founding documents of our nation is the Northwest Ordinance. Mm-hmm. In the Northwest Ordinance, the greatest piece of legislation passed by the Confederation Congress, just while the Constitution was being drafted, the Northwest Ordinance set up how this territory, which became 5 states, could become states, and they set it up that each state would come in as equal to every other state. Never happened before. The states that had fought and won the revolution, they knew that eventually they're going to be outvoted. What an extraordinary thing. On the principle that other sovereigns were equal to them in dignity. They would come in as equal, true sovereign equality. Boy, does that hit home. So now the federal government cannot cherry pick among states without really a strict scrutiny type of justification. Well, a couple of other things he seems to be doing. And then I'll close up and tell you what I think his agenda is and what the future may hold. Small thing. Small thing. Garbage again. Oh, the Supreme Court loves garbage cases. Garbage cases and girly cases. I teach the First Amendment. It's the dirtiest course in the whole curriculum. We're talking about strippers and girl, what's free speech, and there's nude dancing, expression under the first. Come on, give me a break. Go down to what's that place called? Crazy Horse. Do your research down there. So garbage case. Well, the Supreme Court has held again, New York and New Jersey again, the Supreme Court has held that a state cannot discriminate against out-of-state garbage. Garbage is a commodity. You know, people sell it, people use processing plants. So the state cannot tell a processing plant, say in New Jersey, this was a Pennsylvania case, Pennsylvania, you can discriminate against out-of-state garbage. You can take home state garbage first come, like that. Or you can charge higher for out-of-state garbage. So the Commerce Clause doesn't allow discrimination against out-of-state businesses in the same market. And there's good reason for that. There's a good reason for that. So, okay, so that's black letter law. So then in a case called upstate New York, Herkimer, Utica, up in that area. This garbage district, this refuse district, actually opened up its own processing plant. It owned its own processing plant, and then discriminates against the out-of-staters. And Justice Roberts says, right on, you can do that. What? How can a state do something because it owns a plant when it couldn't pass a law allowing a private plant to do the same thing? Because he says that refuse collection is a traditional function of the sovereign states. Gosh, he is pushing these boundaries. Why, is refuse collection really necessary for sovereignty of the states? No, but he's laying down markers. He's laying down markers. And then his final triumph, although we all know it is tainted because he allowed Obamacare to go through, is within that case, he got 7 votes to strike down the Medicaid compulsory process. Under Medicaid, the government, if you recall, and of course it's a debate now within our state and within our government and the Republican legislature, under the misnamed Affordable Care Act, the oxymoron, the Affordable Care Act, under that provision, Medicaid has to be expanded to a population of, I believe, 133% of the poverty level. And if the state did not do it under the original plan, it would lose all of its Medicaid support. The average state budget spends 20% of the whole budget on Medicaid today. 20%. The whole budget on Medicaid. This was a gun to the head of the states, which says, if you don't expand it the way we want, we're going to leave you high and dry. We know you can't afford to get out of that. And for the first time in history, the Supreme Court held that Congress exceeded its constitutional limits in the spending power. Every other attempt of Congress to say, if you do X, we'll pay Y, but you got to do X, the Supreme Court's approved it. In this case, the Sebelius case, Chief Justice Roberts said, this became coercion. This was, in effect, conscripting the states into the federal program by beggaring them if they didn't go along. And he got 2 liberal votes to go along with it. That is a big precedent for states' rights. So we're a long way from there. But I don't know if we can, let's see, are we going to get, when I was young, can I finish with this? When I was young, there were great comedy records. One was Tom Lear. I don't know if you knew, ever heard of him. His great songs. Fight Fiercely, Harvard was one of his songs. Another was Bert and I. Did you ever hear Bert and I? It was by 2 Vermont students, huh? Bert and I. Right?
You get there from here.
Yeah, well, you just stole my punchline, right? So, Bert and I, these Mainers, right? Bert and I are sitting on the front porch. And up comes a flivver. You know what a flivver is?
Yeah.
It's an old-fashioned name for an old jalopy. Up comes a flivver. How do you get to East Wallanocket? Well, you take the road up to Augusta, and then you turn right and you head towards Well, no, you should take the Shore Road up to Stonington. And when you get to Stonington, go around the mountain. No. You can't get there from here. So can Justice Roberts get there from here? Can he not create, but help us find immunities, safe harbors from this overweening coercive government? You can't even paint your house now because of what the EPA does. You can't do your house. You can't put a sewer line in without the EPA telling you what you can and cannot do. Can we create some kind of residual sovereignties, some kind of safe harbor in the churches? That's what's going to come before the Supreme Court on the Obamacare. Can he do it? Well, he's working incrementally. Why incrementally? I think he's working incrementally because as he takes each step, it becomes more and more locked in doctrine. If you try to hold big step, he may not get the votes, and as soon as one of the conservative members is replaced, everything will go. So what's the ultimate result? Well, the ultimate result is what you and I now know. The ultimate prospect and prognosis. And that is, for a good deal of his office now, the president has become the chief elector of the Supreme Court. We vote for him according to whom we think he will appoint. That means it's up to you. We have to get the numbers. We have to get the Congress, and we have to get the presidency back for these, may I, baby steps to become giant steps. So I wish you and us all well on your quest. Thanks.